topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show. I'm your host, Steve-O. This is the first Thursday of the month. And if you've been with us long enough, you know that means K. Bender Rimbaum, their community association law firm. Before we get started, I want to tell you, we do about 40 shows a month. It's a lot of live shows. And K. Bender Rimbaum, South Florida, is not only are they our number one show, but no one is even close. They've been with us for a little over 10 years, and we still get people who swear by it, who will say, I never miss a show. People love this show because if you're in a community association or an HOA or a condo, this is just the greatest show. We're so lucky to have this firm, K. Bender Rimbaum, and let's welcome the senior partner. Good afternoon, Robert.
Hello, everybody.
Well, you got a busy month this month.
We do have a busy month, kicking off the fall season, as it were.
Well, we will be going over this during the show. And, you know, what we like to do with the show is we open it up to you, the listener, the viewer. And what we do is we take the questions, the emails, your texts that we get over the month, and then we use them during the show. In fact, Robert rarely even knows the questions we're going to ask. But this is a great forum to do it this way. Let's start. Before we get started, we had like 8 people just today write us and said, hey, I just found your show. I looked at some of the past shows, and we'll be listening in today. That's just today. So we're always getting new people. So, Robert, tell people about K. Bender Rimbaum.
Okay, Bender Rimbaum is a full-service law firm that focuses on community association law, condominiums, HOAs, cooperatives primarily, providing legal services to the associations. We cover all aspects of the day-to-day legal needs of associations, and even some that aren't so day-to-day, dealing with interpretations of what the governing documents provide, both from the association's rights and obligations and that of the owners, dealing with contract negotiation, dealing with code enforcement issues, construction defect issues, both in and out of litigation, collection of unpaid assessments, anything that an association will be facing on a day-to-day basis are the legal issues that we address. We do provide these services, have continuously since 1992, main office in Pompano Beach. We have Palm Beach Gardens. We have Orlando, now Winter Springs, and Tampa. We also have a meeting center in Miami-Dade by appointment only. So from those places, we're covering most of Florida, at least the southern half of it. We do get a little bit north of our northern offices, and a lot of things that we do are done via Zoom meetings and emails. So where we're located isn't necessarily a limitation on how we can provide assistance to associations throughout the state.
Well, are you ready for some questions?
I'm ready for some questions, and we've got a busy month of courses coming up, so we want to get those all out there so everybody knows. In fact, one of them is immediately following this show at 6 o'clock today, so somebody might be interested in that.
Want to go over your schedule first?
I might as well at least get that in. Maybe we can do that again later.
That'll be good.
Today at 6 o'clock, Kirsten Hens from Tampa will be teaching board election process webinar. So that one's already got a lot of people signed up, but there's room for more. You go to our website at kbrlegal.com, click on the calendar, click on that particular seminar so you can get the credentials to join that one, and that'll be 6 o'clock today. On September 9th at 6:15 in Tamarack, Michael Bender will be attending a live meeting called Empowering Residents in Condominiums and HOAs. It's a town hall with members of the city and some state representatives will be in attendance in Tamarack at the city center there on Commercial Boulevard. Then on September 10th at 11:30 a.m., Covenant Enforcement for Community Associations, a webinar with Alan Schwartzide of our Orlando office with host GRS Management. That's at 11:30 a.m. September 10th. Then on September 11th at 11 a.m., Emily Gannon from Pompano will be teaching with host American Community Education. Importance of updating your governing documents. That's at 11 a.m. on September 11th. Then on September 17th, funding construction projects. That will be a live event at the Doral Dave & Buster's. Michael Bender will be instructing for CAMU, 11:30 a.m. September 17th at the Doral Dave & Buster's. Michael Bender. September 18th. At 5:30 p.m., Tech and Community Governance. That's another live presentation at the Top Golf in Tampa. 5:30 p.m., September 18th. Kirsten Hens will be part of a panel and is hosted by Get Quorum. Then on September 19th, unfortunately, we have a fully booked 4-hour condominium certification course. This is the first of the division approved condominium certification courses that all board members are required to take. This is the 4-hour version. There will be another one upcoming on October the 2nd with Campbell Management. There will be an announcement on that one coming up soon. That's going to be on October 2nd. I don't have the details yet, but you can keep track of that on our website at kbrlegal.com. And then there will be many more as the year progresses and into 2025. On September 20th at 12 noon, importance of updating your governing documents. Kirsten Hens from Tampa will be discussing that for an hour on September 20th. Then on September 23rd, a legislative update for homeowner associations. At 12 noon, Jeffrey Rumbaum will be joining with Campbell Property Management to discuss that topic, changes in the law for homeowner association. And then on the next day, September 24th at noon, Michael Bender will join with Campbell Property Management for a legislative update on the condominium changes. So those are the items we have upcoming in the month of September. So if you're interested in any of those, just go to our website, kbrlegal.com. Click on the calendar, choose whichever event that you're interested in, and reserve your spot. The live limited opportunities than the Zoom events, but the board member certification is actually a Zoom event, and we've got more reservations than our Zoom can accommodate. So that's why we're fully booked on that.
And those are now, is that right? Those are now 4 hours long?
They will be 4 hours, yes, for the initial certification.
Okay. So, and I tell you, we'll do this the second half of the show again You have got a busy month.
Yes, we do.
Let's go to our questions. Let's go to John. What happens when an HOA goes into receivership?
Well, it isn't just an automatic thing going into receivership. If an HOA does not have enough people to meet a quorum of the board so that it can function in accordance with its governing documents, it would take an owner within the community or member of the association to file a petition with the circuit court in the jurisdiction of where the property is located, requesting the court to appoint a receiver to take over that role until such time as there is an election enabling a quorum of the board to be seated. It's a problem for that community in that once a receiver is appointed, that receiver in essence is in the place of the board of directors and makes all decisions for the association. That receiver also is billing an hourly rate, probably in excess of $400 an hour for the receiver's time in providing those services. The receiver also is in a position to hire, they'll likely hire an attorney to represent the receiver, in addition to whatever attorney might be representing the association. All of the expenses of the association will be at the discretion of the receiver. So the things in that particular scenario can get very expensive for a community very fast. So it's best to not be in that position. And the way to do that is make sure you always have enough people willing to be on the board and serving in that capacity, so at least there is a quorum of the board available.
Okay, let's go to Cecil in Delray Beach. This is a two-part question regarding HOA board meetings. If a board meeting is done by Zoom, does it have to be recorded? And the second question is, if it's recorded, is it now part of the record and must be kept for 7 to 10 years?
Well, the first part of that question, a Zoom meeting, the law doesn't require it to be recorded, but minutes need to be kept. So in some instances, a board may record the meeting so that it can be used, the recording, to assist whoever's preparing the minutes to make sure they cover everything. And then once minutes are created, then that recording can be discarded. If, on the other hand, the board decides to maintain recordings of board meetings, then those recordings would be treated as part of the official records, and they would have to be maintained as any other part of the official records. So it really depends. It's not a requirement to record or to maintain, but once the board decides to do so, then there are obligations with respect to that. Now, the board can change its policy at any time. So if they've kept recordings for a year and decide, well, we don't really need these, and they change their policy so they're not keeping recordings anymore, they can do that as well.
Okay. Mark in Pompano, I'm thinking about running for our board. What are the responsibilities of being a board member?
Well, that's a good thing to be thinking of when you are a member of a community association, and that everybody should at some point be participating in the operation of their community association if they can. Like some very large communities, it's more difficult to get involved in the political process because you still have to get elected, and so that can be a daunting process for some. But in a smaller community and a more manageable one, it's likely that most anybody, so long as they're not controversial within the community and creating issues within the community, should be able to find themselves in a position to get on the board. Each community, of course, is going to depend. The responsibilities are primarily governed by what your documents provide for, and in concert with Florida statutes, and most of the contained within Chapter 617, the Not-for-Profit Corporation Act. And if your HOA is Chapter 720 and condominiums Chapter 718. The responsibilities of a board member are initially to vote on and assist in the process of creating policy for the association. On any issue, most require the approval of at least a majority of the board of directors in order for them to occur. So being aware of the issues, educated as needed on everything that is involved in whatever issue is before the board. The basic function is to attend board meetings and to vote. Now, some boards create additional duties and responsibilities of its membership. And so that's going to depend on the individual community as to what responsibilities. Quite often, board members also serve as officers of the association, and it's going to depend on what the documents provide relative to that. But that's like wearing a different hat. If you're going to be on the board and you happen to be appointed president for that association, the president is the chief executive officer of the association and carries out primarily whatever policies that the board has approved and adopted. The president doesn't necessarily make specific decisions that aren't in sync with the decisions that the board had already made, or the powers that the board has granted to the president over and above what's generally done by the chief executive officer of the association, which tends to be running meetings and making sure the business of the association is accomplished. But that's not a board responsibility, that's an officer responsibility. And while it's the same person, they're legally different. So that's a general overview of what boards do.
Robert, is there a way to tell a person how many hours, say a week or a month, someone might have to put into being a board member?
Well, it can be as minimal as none to as much as full-time job, depending on the community and how they function. A lot of communities will have professional management, and a lot of the main part of the operation is handled by the property manager, and the board will be kept abreast of what's going on, but their time involvement becomes primarily going to the meetings. The officer duties tend to have more time commitment. And not all directors are likely going to be officers. It's depending on the size of the board and how many officers you have. So the time commitment is going to vary from community to community.
Let's go to, I think this is a long-time listener, MH. If you have some questions on balance sheet values and they are brought up at a board meeting, is someone required to answer your questions, or can they just ignore you?
Well, owner input at board meetings is something that was put into the statutes over the years, and that typically involves agenda items. And when owners do offer their input to the board, there's nothing in the law that requires the board to accept the input or even respond to it. It depends on the makeup of the board and their general proclivities, but it's still a political situation. So politically, you don't want to ignore the owners that are speaking to you about issues involving the association. And quite often, what we advise the board to do is respond that their concerns have been noted and they'll be looked into and as needed and responded to accordingly, not necessarily right there on the spot, but at some point. So that if it's a bona fide issue that the owner is bringing to the attention of the board, it's not being ignored. Unfortunately, the law does not obligate the association to do that. So legally, they can't ignore the owners. Politically, it's not necessarily the right thing to do.
Here's a question from Beth. She wants to know, what steps can a condo association take if they have a resident that is a hoarder or has a unit that is questionable?
Hoarders and people that don't maintain their unit has been an issue that's problematic as long as I've been doing this. It doesn't happen everywhere or a lot, but when it does, it's creates unique problems for the board in addressing them. What goes on within a unit generally is not going to fall within the purview of the association unless it encroaches into the common elements or affects other units. So quite often, a hoarding situation can be ongoing for a long time before it even becomes something the board is aware of. Often, rats or other types of vermin that find their way into the hoarding spread into other parts of the community, and then the board discovers it. Legally, we've had to take people to court to compel them to resolve the situation. The courts are generally responsive to the needs of associations in doing that. We've had situations where the unit owner dies within the unit and nobody knows it for a while. And there's been a lot of hoarding, and then there's all this. It's a big and potentially expensive problem for an association to address, but they still have to do it. And they end up having to clean out the place, get rid of all the garbage, and have whatever biohazards are there properly addressed. So there's no good answer to how to address it, but the important thing to do is as soon as the board becomes aware of the problem, get with your counsel and address it sooner rather than later.
Hey, John, we're going to go to, Robert, we're going to go to break, and tell people how they can reach your office.
You can reach any of our 4 offices by calling 800-974-0680, or you can write to us at info@kbrlegal.com, or you can go to our website, kbrlegal.com. There's a contact box on the first page that you fill out, and somebody will respond to that.
Okay, we're going to go to break. We're here with Robert Kay of K. Bender Rimbaum. We will be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We're here with Robert Kay of K. Bender Rimbaum. This is the first Thursday of the month. We always do a show every month at 5 o'clock, and we ask if you'd like to send your questions in. We have a chat line. We also have our text at 954-336-3767. Let's go to Melissa. She wants to know, with all the new laws, is there any easier ways now to get a renter that is past due out of their condo?
Well, that's not an association issue. That's a landlord-tenant issue of a unit owner. The condo laws don't really address a non-paying renter and how a unit owner deals with that. That's the landlord-tenant statute in Chapter 83. There is a summary procedure that the statutes provide for, which means a faster legal process in dealing with evicting tenants who don't pay rent. And so that it's advisable to hire an attorney who does that type of work and address it.
Okay.
An association can address a non-paying tenant when the owner is delinquent, and the laws give the association the ability to demand the rent from the tenant. And if they don't pay the association, in many instances, the association can evict the tenant on behalf of the owner. It's not something that typically occurs because in that setting, the association's already not being paid on the unit, so they're not going to necessarily spend more money to evict a tenant, which won't get them their money. It just costs them more. So quite often that's not the remedy that's chosen.
This is from Brad. What is the recourse for owner who is exceeding condo of number of residents of 3 per condo with our docs? Has 2 families living in this condo?
Well, if there's a limitation on the number of occupants in the governing documents and somebody exceeds that, generally that would be treated in the same way as any other violation of the documents, with one specific and important exception. If there are children living within the unit that are below the age of 18, and you're in certain counties in Florida particularly, that creates a potential for a discrimination claim based upon familial status, families with children under 18. Some counties have ordinances that indicate children under age of 10 count as a half a person for the purposes of occupancy limitations and calculations. So there's a county issue that's a potential problem. There's the federal and state fair housing laws, which are potential problems when you're having a disparate effect on families with children. So you have to address those situations carefully. Certainly you want to get with the association counsel to evaluate the situation before taking any firm action on pursuing that issue. But in general terms, if you don't have the children issue in the overstuffed unit, then you can get a court order compelling them to bring it into compliance. That wouldn't be a overly complex situation unless the residents make it so by hiring an attorney that games the system.
This is a great question, I guess, this time of the year. Robert, I love your show. We try to listen to it every month, myself and several board members. I'd like to know, with the new laws that are coming out, are there anything pertaining to hurricane?
Well, the hurricane situation in community association involves the requirements of associations to have specifications in place for hurricane protection, alterations within the community, what's expressly to be allowed, and to facilitate the ability of owners to protect their property from the potential damages that a hurricane could cause. Other than that, the new laws don't really do anything different than was already there.
Nothing, Robert, about when you have to take anything down after a hurricane has passed?
Not in the statutes. There is some provisions in the new HOA laws that deal with how long, but the way they do it is they say the association can't begin enforcement until a certain thing, but it doesn't address hurricane issues. Those have to do with garbage cans and other items that don't really belong in a statute, but for some reason are.
Let's go to Eileen in Boynton. How will not having Kaufman language affect the association concerning the new laws?
Well, that's what I was alluding to a moment ago. The Kaufman language, for those who may not be aware, Kaufman was a case, Kaufman versus Scheer, many years ago, in which the court was evaluating whether changes in the statute that happen on an annual basis almost are effective and what laws govern that particular community. So when a community is created, a declaration of covenants or a declaration of condominium is prepared and filed in the public records. The way the law and the Constitution are interpreted is that whatever laws are in place at that day are the laws that apply to that particular community. So if a community is created in 1992 and does not have what's known as the Kaufman language within the documents themselves, the laws in place on that date in 1992 are what applies on a substantive basis. Now, there's two types of statutes that come into this analysis, one that's called substantive and the other is procedural. Substantive are dealing with vested contractual rights, and it's a very complex legal issue that would take a long time to discuss and beyond the scope of this particular type of a show. But certain changes in the law are determined to be substantive, and they would not be effective against a community that does not have language that incorporates changes in the statutes as they are amended from time to time. That's the magic phrase, as amended from time to time. When it's identifying what laws apply within the documents, that is the Kaufman language. So if there's a change in the law, and there are many changes in the law this year, particularly in the HOA setting, which do affect vested contractual rights. One example of that change would be a provision that says a community cannot enforce against certain types of vehicles if the owner is using them as their primary vehicle, even though the documents specifically prohibit them. And so the vehicle issue is a vested contractual right under the declaration. Eliminating the ability of the association to enforce their own covenants without Kaufman language would be a violation of federal and state constitutional provisions, which in essence state that the state will not adopt a law which will conflict with an existing contractual right. That's called the Contracts Clause. It doesn't allow the government to create laws that changes your contract. So in the Kaufman case many years ago, it said if this specific language is in your documents, then new changes to the statute automatically apply. And for many years, a lot of communities just naturally, when amending, would put that in their documents, expecting changes in the law not to be what they would consider objectionable. Many communities did not. So that's what creates the issue. So for any homeowner association in particular, because homeowner associations and condominiums are a little different on this point because condominiums don't exist without the statute. But there could not be a condominium because of the type of ownership of real property that it is. Technically, you don't really own any actual real property in a condominium. You own the space within the four walls that surround your unit. and not anything underneath, which is the actual real property. So it was a creation by statute of a method of owning property. And that's how you own in buildings that go up above one story. So in homeowners associations, it's different. Homeowner associations existed prior to there being any statute. The only statute that applied to homeowner association was the not-for-profit corporate statute that dealt with the corporate functions of the association itself. So any provisions in the statute that are addressing homeowner association covenants are substantive changes to those contractual rights. And the state doesn't really have the ability constitutionally to adopt many of these things that they do. Now, whether or not a judge is going to recognize that or an association is going to raise that as an issue in a case that involves any of these changes is still an open question. And whether or not any of the changes in the laws this year are going to be challenged based on that is still an open question. And it's going to take years for that to flesh out, because first it goes through the lower court, then it has to get to the appellate court, and somebody's got to be willing to appeal it, and then it's the appellate court that makes the decision that's actually legally effective throughout the state. And ultimately it may get to the Florida Supreme Court. It really depends. But that process takes years to accomplish. And since the changes just happened this year, we're still a ways off from seeing what those results are.
Let's go to John in Palm Beach Gardens. Many property managers are realtors. Is it a conflict of interest for a property manager to agent that building sales or rentals?
It is a potential conflict of interest, but not necessarily an actual one. If the realtor is not using his or her position as a member of the board and using special knowledge gained by their position on the board to assist them in making this personal gain of selling or renting property for their commissions, if that does not happen, there's not really a conflict of interest. They're just doing their job, and they happen to be representing stuff within the community that's really not intertwined with the association's operation. That being said, it's a recommendation that anybody doing that makes full disclosure to the board that they're doing that, and that the board is aware and does not find it objectionable. And if the board does, get with your counsel and determine whether or not it's a real issue for that community, and determine what course of action will be or should be taken.
John, I think this would be probably a good time to go.
Still not John.
I don't know why. This is the first time in 10 years. I don't know why, Robert, but
we don't even have a John.
Yeah, but you should see all the Johns we have on here, though, on our questions. I'm looking at 3 of them right now.
That'll get you.
Yeah. So can we go over your schedule again? And I just want to tell everybody.
Busy month for those latecomers.
Yeah.
Today, actually, following this broadcast at 6:00, we have board election process. Kirsten Hens from our Tampa office will be presenting. So go to kbrlegal.com, click on the calendar, click on that particular item to get your credentials so you can participate in that. On September 9th at 6:15 p.m. in Tamarack, Michael Bender will be a guest presenting empowering residents in condominiums and HOAs in a town hall setting. There will also be members of the city and state legislature participating in that forum as well. On September 10th at 11:30 a.m., Covenant Enforcement for Community Associations, a webinar. Alan Schwartzide of our Orlando office will be presenting with host GRS Management. Importance of updating your governing documents will be presented on September 11th at 11 a.m. Emily Gannon from Pompano Beach will be presenting with the host Association Community Education. On September 17th at 11:30 a.m., Funding Construction Projects will be a live presentation at the Doral Dave & Buster's by Michael Bender with Cam U. On September 18th at 5:30 p.m., Tech and Community Governance. That will be another live presentation in Tampa at the Top Golf in Tampa. Kirsten Hens of the Tampa office will be presenting, and the host is Get Quorum, September 18th, 5:30 p.m. And we are having a 4-hour condominium certification course on September 19th, but I'm told that it's already fully booked out, in fact, overbooked for the capacity of Zoom. So the next one that we're likely to have will be October the 2nd. Details for that will be announced shortly. We don't have that completely formalized yet. That will be in association with Campbell Management on October the 2nd, a 4-hour condominium certification course. On September 20th at noon, Importance of Updating Your Governing Documents webinar with Kirsten Hens from the Tampa office. On September 23rd, a legislative update for the Homeowner Association laws. Jeffrey Rembaum from Palm Beach Gardens office will join with Campbell Property Management at 12 noon. And then the following day, September 24th, also at 12 noon, the legislative update for condominium associations. Michael Bender from our Pompano Beach office will also join Campbell Property Management to make that presentation. So that's upcoming in the month of September.
Busy. Wow.
Anyone interested in any of those, go to our website, kbrlegal.com, click on the calendar, choose the event you want, get yourself registered for the credentials you need to participate.
Okay, let's go to John again in Pompano. We have a small HOA and find it a problem to get a board of 3 people. Any ideas how we can get more people involved in the board?
Well, one tongue-in-cheek answer to that would be announce that a major assessment is being considered, and you'll see how many people come out of the woodwork to attend your board meeting, and then you can recruit them to get on the board. But I'm sure no one wants to really go through that. It's a difficult issue when you have a community that's being well run, that nobody has any issues with. It's a small community, and nobody's interested in spending their time in participation of that. There's no real good answer as to how you get people interested. The best method is through the political process of communication within the community. Do it via newsletter or emails, communicating to the membership all the things that are going on and the need for the participation. And you can be talking to your neighbors and doing your best to, I guess, generate interest in that. If somebody's not going to be interested in how the place works, then that could be a problem. The other would be the notification that if nobody steps up, then you'll have no alternative but to go the receiver route that we talked about earlier, which would involve a large expense to the association for the receiver's time and whatever expenses the receiver decides he or she should be spending. And sometimes you just have to go that route. It's not ideal.
You know, Robert, I'm surprised we get a lot of questions about elevators. Here's Gene in Coral Springs. Do we have to fund reserves for elevators?
Well, elevators most likely will have deferred maintenance costs that will exceed $10,000. And that's an item in the statute that is required to be reserved. So that the likely answer to that is going to be yes. Everyone should be having reserve studies undertaken, no matter what size their condominium is. And the reserve studies will provide the association board with recommendations for the items that should be reserved for, and creates the formula of the replacement costs against the useful life.
This is going to be the last question about vehicles with any of the new laws. Actually, work vehicles can now park in your own spot or driveway, not allow work vehicles to park in your own spot or driveway.
Well, we actually talked about that a couple minutes ago with the Kaufman language issue. That's a change in the statute that was adopted this year that may or may not apply to each individual community depending on what their documents contain as to what laws apply. We have seen a number of communities already without Kaufman language have responded to that change to their owners by informing them that it doesn't apply to them and that they're still bound by what the covenants indicate. So there hasn't been any court action on that as of yet. So you need to first check your documents to see if there is a Kaufman provision within your documents. And it relates to the specific issue, because some communities have gone to putting Kaufman language in as to specific provisions as opposed to all of the restrictions in the documents. So there's also a question as to whether or not, if it's anywhere in the documents, the court's going to apply it to all of the documents or just as it was intended to the specific provision. And that's a way to deal with it.
Robert, we got a couple minutes left, and I think it's just so important that a condo or HOA and association have a good firm that understands community association law, like K. Bender Rimbaum. There's always new properties opening up. Tell people out there that or maybe they're not happy with their representation, why they should retain K. Bender Rimbaum.
Well, K. Bender Rimbaum is made up of a large number of board certified community association specialists. This is a qualification established by the Florida Bar for people like myself who specialize in this area of the law. There's a little over 200 in the entire state, and we have, I believe, 10 of them in just our firm. And we also have a board certified construction defect litigation attorney as well for those more complex construction related issues, particularly for newer communities that have recently turned over from their developer. Usually the first step that occurs is an evaluation of the buildings and some form of claims being made against the developer for whatever defects are found to be, and we provide board certified assistance as to that. Combined community association experience exceeds 100 years. I haven't done a calculation of late, but we focus on this area. It's 90+% of what the firm does. And our aim and mission has always been to provide the most effective and cost-efficient legal services to our community association clients. And part of that is being responsive when they need us and to provide information in a manner that's readily understandable to the layperson. That's our general policy on how we try and provide our services. And sometimes things are technical and it's hard to get away from the technical aspect of it, but we're always striving to do so. So in a nutshell, that's who we are and why we should be considered.
Well, that's going to do it for us today. Tell people how they can reach your office?
You can call us at 800-974-0680, or you can write to us at info@kbrlegal.com, or you can go to our website at kbrlegal.com. There's a box on the first page for request for a contact, and just fill out the box, and we'll get back to you right away.
Robert, we are so lucky to have your firm as our expert. Again, Robert will be back with us the first Thursday next month. So get your questions. I am so sorry, all the people who wrote questions in during the show, that we couldn't get to them all, but we'll keep them and we'll do them next month. Robert, thank you so much.
All right. Thank you, Stephen. Goodbye, everybody. See you next month.
Thanks, Robert. That's going to do it for us today. We'll be back again next week with more experts, and we thank you for tuning in today. Everybody have a wonderful rest of the week, and we'll see you soon.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.